Welcome to Do Your Adult Children Know What to Do When You Die? So great question. This is a very common question. People call us. They say, Mom and Dad have passed away. What do I do now? Where do I even start? So I've got here Jeff Rosen, one of the attorneys at our firm here, Cunningham Legal. And my name is Jim Cunningham. And Jeff, any thoughts on this?
Well, in my experience, when something happens to a parent, whether, they pass away, which will inevitably happen to all of us one day, or when their parents get to the point where they're just not able to manage their finances independently anymore, it's a real tough thing to deal with.
Yep.
To see that happen to a loved one, right? And a lot of times people, frankly, think they kind of know the ins and outs of what's to do, but there are a lot of things that have to be done that, at first glance aren't totally obvious. So that's what we're going to explore today. We're going to go over, the things that you guys need to know, whether you're a parent tuning in or whether you're a child who, is dealing with this right now, or, you're going to be in this position in the future. You can pick up some tips today that will prepare you for that in the future.
Great. So we have a disclaimer here. This says, Jeff and I are lawyers. This is information only. This is not legal advice. We're going to go through a lot of stuff here. Please don't take this advice and run off and, go out into the ether and just start doing documents on your own. It's generally not that good of an idea. In fact, it's a terrible idea. There will be Q&A at the end. There's also a Q&A box up there it's either at the top or bottom of your screen. The Q&A bar, you can go ahead and click that and ask a question. And we do have a team of attorneys here at Cunningham Legal. Jeff and I are 2 of 7 lawyers at our firm. I'm there on the left-hand side and Jeff's right smack dab in the middle on the second row. And we've got attorneys in Southern California and Northern California. And in January, we are expanding to the Oakland Hills, which is the Montclair Piedmont area, as well as Napa. So why are you here, Jeff? You want to answer the question, why are all these people here learning about this stuff?
Well, it could be a variety of reasons. Perhaps you've noticed that your parents just aren't as sharp as they used to be. Perhaps they've been diagnosed with something cognitively, and you're not confident that they can manage their affairs. And maybe they've recognized that they're not the same as they used to be either, right? And it may be time for what we kind of refer to as a changing of the guard, right? A passing of the torch. Even if you're not in that scenario right now, someday, you might be the one who's pegged to handle your parents' affairs, right? I'm the lawyer in the family. Everybody has chosen me to be the one that's going to come in and handle the financial affairs when something happens to people. And that's a big job, right? And, you need to know what you need to know what you don't know going into this, right? That's what gets you into trouble. And we're here to shrink that a little bit. Now, one thing a lot of people don't realize, and I'm not saying this to scare you, I'm saying this to prepare you, is that if you're the successor trustee of somebody's trust, for example, you have a fiduciary duty to carry out your responsibilities in the best interest of the people involved. So either the owner of the trust, if they're still alive, or the beneficiaries of the trust. And if you breach your duty, you are personally liable. So you do something incorrectly and you mess up, it's your personal wealth that's at stake. And, how do you avoid that problem from happening? Because it's a conundrum. A lot of people want to step in and they want to be of help. They want to be of service to their parents or their loved ones, but they're a little timid to do that if they know that so much is at stake. Well, one thing we recommend almost everybody do in that position is you get expert help, right? You meet with an attorney like me or Jim or one of the other attorneys at the firm. We're trained on how to guide you through this process, right? And it's not always an easy process, especially when emotions are involved. So we're going to talk all about that. We're going to talk about new laws that have been passed that may impact your current plan. So if you have an estate plan that you did last year, 2 years ago, 10 years ago, folks, we had a big election a few weeks ago. And Jim, a whole lot has changed. And that's going to be a big focus of what we discussed
That's
today.
an understatement. All right. So what do all these documents mean? There's a list of documents there. And I think everyone here is on video. No one is calling in by phone. So, you've got the elements of a complete estate plan. You have a living trust. That's the primary will substitute. And what that means is, people set up they have this bucket that's a living trust, and mom and dad put all their assets in the bucket. Mom and dad are the trustees, but one day mom and dad are going to stop being the trustee. They're going to stop being in charge of the bucket, and they're either going to pass away, which is 100% certainty. I'm sorry to tell you. It does happen. And about 85% of the time, people do need help before they pass away. Either they become incapacitated, or they are just kind of declining and need help. That was my mother-in-law before she passed away this year, and it is my father-in-law now. So my wife is the one taking care of this. So I'm living the dream, as they say. The pour over will leaves everything to the trust. So you put all your assets in your trust, but sometimes assets leak out of the trust. You refinance your house, the property comes out. It's probably the most common instance where assets come out of the trust. And if it's not in your trust, the trustee has no authority over that. So if your parents are the trustee and they stop being trustee and you take over, if that house is not in the trust, Houston, we have a problem. You're not going to be able, as trustee, to have authority over that property. So that's a really big deal. Durable power of attorney, a lot of people know what that is. A durable power of attorney is where your parents name you to be their agent under the durable power of attorney so that you can act on their behalf for things that are not in the trust, like IRAs and 401ks and annuities and life insurance, getting a registered letter, interacting with the Social Security Administration, or if your parent is a retired military person, dealing with the DFAS, which we have to deal with my father-in-law, who's retired Chief Master Sergeant from the United States Air Force. So he's a bossy guy. Advanced Healthcare Directive. That's the document that says these people make healthcare decisions for me. Your parents might say, I want my son or daughter to make healthcare decisions for me when I can't. You absolutely need that, especially, we're right in the middle of COVID. This is a real issue, because if your parent is in the hospital, guess what? You can't go see them. So you need a document in order to, in order to deal with the medical authorities. The HIPAA authorization says that that's where your parents grant you access to their health information. Not always that you make a healthcare decision, but that you have access. And so we separate those two documents out. A POLST is the physician's order regarding life-sustaining treatment. That is a medical directive. That is a medical order. An advanced healthcare directive is a legal document, and here's the difference. A legal document requires someone to decide on something. A POLST is a medical order, and the medical practitioner follows the order. Nobody decides. So that's the fork in the road. Not everyone has a POLST. Most people who do an estate plan, and pretty much everyone, does an advanced healthcare directive. A POLST says, if I choke on a peanut, don't give me the Heimlich maneuver. Just let me go. So, and there are varying degrees of that, but I, say that in a little bit tongue in cheek, just to let you know that it's different than the advanced healthcare directive. And then a living will says, hey, if I'm a goner, if I'm at the end of my life, it's okay to let me go. So very important documents. You want to talk about funding your trust, Jeff?
Yeah. And, frankly, guys, this is one of the things that we see kind of done incorrectly most often. And so what does funding your trust mean? Well, most people spend so much time getting their trust just the way they want it. I know me and my wife, when we did our trust and when we updated it, when we had kids, we spent a whole lot of time getting the trust just right. And we finally both agreed on everything it said. We signed and notarized it. And if that's all we did, if we passed away, our trust is not going to be very valuable, because we haven't done the second important step, which is funding our trust. So, a lot of our assets, not all of them, need to actually go in the name of our trust. So we have a house. We transferred the deed to our house to our trust. Our checking and savings accounts are in our trust. Our non-retirement investment accounts are in our trust. Some people have IRAs or 401ks or other retirement accounts. Those are examples of assets that do not go in our trust. But when we talk about putting something in our trust, we literally mean retitling the asset to be in the name of the trustee of the trust. That's how you know that the asset is subject to control by the trust. Why do you need to have that? Well, for one, if the original owner of the trust gets sick and can't manage things, the successor trustee needs to be able to step in and manage those assets. Their name needs to be put on the property as trustee of the trust. Second, and one of the real big ones, is if your trust isn't properly funded, when you pass away, your estate goes through probate, right? Now, if you've done a trust before, you probably remember one of the reasons you did a trust was so there is no probate court when you pass away, right? But you have to have your trust properly funded in order to avoid that.
Sorry about that.
Yeah, no problem. So one of the big risks that we see is people have a very, they have a set it and forget it mindset towards their trust, right? They say, well, I did all that with the lawyer 15 years ago, everything should be fine. And you need to pay very careful attention to the changes in your assets over time, right? Your bank account number may change. You may move your assets to a different institution. As those changes in your assets occur, your trust needs to stay up to date with that. So, we'll remind you throughout this presentation, but we recommend our clients have review meetings with us about every 3 years. One of the reasons we're having those review meetings is to review whether the trust is properly funded.
Well, and actually the reason we have those review meetings is we care about you guys who are our clients, right? And so we want to make sure that your estate plan is successful, because that's actually why we get up and go to work every day. Now we're not going to an office anymore. We're doing all of our meetings by Zoom. My commute is about 15 feet. I don't know how far yours is, Jeff, but it's just not that far, but we're here to help you guys out. Now, this is very important. Assets that are outside of the trust, okay? Very, very important to pay attention to. These get separate treatment when a parent is incapacitated. There are a lot of lawyers who don't even know this, okay? Here's the deal. If you have assets that are in your mom and dad's name individually, it's just their name on it, a bank account with $10,000 in it, or there's a POD or a TOD account. Now, what that is you can go to the bank and you can say, I'm going to put $10,000 in here and I don't want to put that into my trust. I'm not suggesting you do this, but you can do, this is possible. You can say there's $10,000 in this account. And when I die, Johnny, whoever Johnny is, my kid, maybe Johnny gets this account when I die. So when I die, Johnny comes in with the death certificate and he gets that money. That does not flow through a trust. A TOD is typically at a brokerage firm where you might have a stock or a bond that is transfers on death. Those are typically the two acronyms that we see. It's functionally the same thing, which is the holder of that account or the holder of that asset, when that person dies, it transfers to the beneficiary without probate and without going through the medium of a trust. Now, here's the problem. If mom goes to assisted living and her income is $3,000 a month and her bill is $6,000 a month, you've got a $3,000 shortfall. What bucket of money do you take money out of first? Do you take it out of the account that's in mom's name for $10,000? Do you take it out of the living trust that may have Johnny and Sally and Susie as beneficiaries? Or do you take it out of the POD account where Johnny's the beneficiary? I can tell you, if Susie is the trustee, she's probably going to want to take Johnny's money out first. And that is a violation of the order of liquidation of assets for an incapacitated person. Susie would be 100% personally liable for wrongfully using mom's own money for mom's care. This is crazy. But you know what? This does happen. So this is where you do need to involve an expert lawyer. Now, we don't see POD accounts or TOD accounts every day. We do see joint accounts where maybe mom put Johnny on an account jointly. It's all mom's money. Mom adds Johnny on the account, because Johnny needs to go get groceries for mom, but Susie is the one who's the trustee. So again, same issue comes up. What is the order of liquidation of the account? So very important. This can be the spark that starts the wildfire of litigation after somebody dies. So you really do need to be mindful when it comes to how you're going to pay for the care for an elder. All right.
And I think, Jim, one trap people fall into is, when you have a POD or a TOD, so long as the beneficiary is living when the owner passes away, that asset avoids probate court. And I think a lot of people hear that and they say, well, gosh, how easy is this? I'm just going to set up POD. It avoids probate. This is great. The risks are what Jim just described. And the additional risk is the person you name as the beneficiary may not be alive by the time the original owner passes away. And then you have a slew of other problems.
Yeah. Then you have a probate for the person who was supposed to inherit it, and terrible. So looks like we have a question. Jeff, you want to answer? You want to cover this slide?
Yeah. So,
wait a minute. Somebody asked, what's the correct order of liquidation? I can't remember. I'd have to look at it. But if you're in that situation, if you just want to know, just for knowledge sake, that's one thing. If you are caring for an elder and you've got different pots of money, if you're already represented by an attorney, go back to that attorney. If you're not represented by an attorney, or you're one of our clients, because a lot of our clients who are being represented do come onto these webinars, then please give us a call and set up a 15-minute call.
Yeah. So, at some point in time, when somebody, has some type of estate plan, there will come a time where they're not serving that role anymore, and somebody else needs to step into the shoes of that original person to get work done. Now, a lot of times before somebody passes away, they experience a period of incapacity. So incapacity is generally speaking, when somebody lacks the mental ability to manage their financial affairs, right? That's kind of the way I would consider incapacity. So how do you step into that role, right? Does it just magically happen? Do you just say, hey, you're just not all there anymore, I'm going to take over? No, there's a process that you have to go through in order to step into those shoes. Now, typically what we do is we'll look at the existing documents to see what is the procedure that the documents call for to facilitate this transition, right? So usually we'll look at the trust, we'll look at the durable power of attorney, and there usually will be a section that says, hey, this is the criteria that has to be met for the next person to have to carry out this role, right, of managing the assets. So for example, sometimes the trust will say that you have to go to court to determine who the next trustee is, right? If the original trustee is incapacitated. Sometimes it requires that 2 independent physicians review the original owner of the trust, and they have to agree that they are no longer capable of managing. One creative thing you can do is you can have what's called a disability panel. So you don't have to leave it up to the court. You don't have to leave it up to physicians to make that determination. In some instances, you can choose a group of people who have to unanimously or by majority meet and make that determination in good faith. And that can determine you're incapacitated, and that allows the next person to step into your shoes and get the job done. So, one potential problem is, perhaps mom or dad, they're not totally gone mentally. They're still with it, but they've just gotten to the point, maybe they're older in age, and it's just terribly difficult for them to get around. They just can't get off the couch and go to the bank as easy as they used to be. And for convenience, they would prefer for one of the children to be able to do that for them. Well, the potential problem is if the documents say that person has to be incapacitated before the next person in line can step in, you got a problem. So one thing a parent can potentially do is they can resign. Sometimes they can appoint a co-trustee, or they can appoint the next trustee to serve. This is really important. I've spent a lot of time talking about this because this is something that is very simple, but gets people into trouble as time goes on. So if you have a very simple estate plan that you did years and years ago, or it's just not up to date with today's law, it may not be equipped with the language necessary to make this transition easy.
Yeah, what we see is, especially on older estate plans, it's like a binary estate plan. It's zeros and ones. It's either the person is alive or they're dead. Either they're incapacitated, either they're capacitated, right? They have capacity, or they're incapacitated. It doesn't address this sort of twilight period of sort of diminishing capacity where they might, there's a lot of dignity associated, or loss of dignity associated with aging. I'm seeing it with my father-in-law, and it's not pretty. And, when you're a chief in the Air Force, retired chief in the Air Force, you're used to being in charge, and he does not like aging, and he's 88. He does not like that process. And if you're here for a loved one, you probably know exactly what I'm talking about. So prepare for the role. You want to talk about this, Jeff?
Yeah. So, you know, here's something that you may consider doing now, before you're even in the position of taking over management of the assets. One of the most valuable things you can do right now is identify what are the assets and where are they, right? How many different bank accounts are there? Are there online bank accounts? So digital assets and passwords and being able to access that information on a computer is extremely valuable today. And, 10 years ago, it wasn't really something people were dealing with, right? Identifying where income is coming from, right? Is mom and dad receiving Social Security? Is it being auto deposited into a particular account? Is it being deposited into an account that's not owned by the trust, right?
Yeah, and
That's a big one.
that is a big one, because switching where the auto deposit is on Social Security, it can make you want to pull your hair out, because it sometimes, I mean, the Social Security Administration is a great organization, don't get me wrong, but I have just seen through personal experience, when banks say you can't move this account to a trust, you have to open up a new account, that can be really problematic. Okay. Or if they say you can't add someone to this account, let's just open up a new account and close this other one. That's one where you can lose your auto deposit on your Social Security. And it's like trying to move a mountain to get your auto deposit moved, or, once it's shut off, getting it reactivated again. So that's been a problem we've seen clients encounter. And, part of this is not so much, hey, here's a problem and here's a solution for every problem. It's just really paying attention to, before you kind of step in it and start doing these things, it does make sense to reach out to an expert attorney and say, hey, this is what's going on. What are the potential pitfalls? I do want to say one of the other things is that income can be paid monthly, it can be paid quarterly, and it can be paid annually. So typically bank statements arrive monthly. Statements from brokerage firms that are under the Securities and Exchange Commission by law are only required to be sent every 3 months, so once a quarter. So that's why, if a mom and dad become incapacitated, you want to make sure you forward, if they don't live at home, you want to make sure you forward the mail. You want to make sure you get a hold of this, and you want to make sure that you're paying attention to the mail, because it may be 3 months before you get another statement. And then life insurance statements, annuity statements, those other types of statements typically come annually. So you really do need to have kind of a broad time frame when it comes to making sure that you collect all the assets. And to Jeff's point, it is much better if you engage with the elder, with your parent or the person you're taking care of, and actually get a list of assets. Now, that's partly what the Schedule A in a trust covers. A Schedule A lists all the assets, and that's typically where the attorney starts. That's typically a snapshot in time. Let's say mom and dad, the last time they did their trust was 2012. We would say, oh, well, let's start in 2012. This is what they have. Do they still have this stuff or not? And many times the kids will say, I don't know. And so it makes the job that much more difficult. What we also find is sometimes one spouse is more dominant and controlling of the finances. And, you might think, well, it's typically the husband and not the wife, but, not always. Sometimes it's the wife who's in charge of the finances. And many times the more dominant spouse may be the one that's having some mental issues or some mental health issues, some capacity issues. And that's something to pay attention to. We see a lot of people, they try and do it themselves. They say, the mom and dad, they'll say, well, we have a couple $1 million at the bank, and we like to put we don't like to put any more than $100,000 in any institution because they might go bankrupt. So we have 20 CDs all over the place. That's a little bit of flawed logic, because your FDIC insurance coverage is not per institution, it's per account titling, which is a whole topic for another slide, another day. But it is very important to engage the services, or consider engaging the services of a financial planner, because typically the financial planning needs become different when a person has diminishing capacity. Either they have in-home care, or they're leaving the home and going to some type of assisted living or skilled nursing. And many people just don't have long-term care insurance. They don't have a long-term care reserve. They just haven't really planned for it. And Anil asked a question, does Schedule A generally include the retirement accounts? Generally, no. Anil. The Schedule A does not include the retirement accounts. But what we find is many lawyers who don't really know much about retirement accounts oftentimes will list them on the Schedule A. So it's a good place to, frankly, it's a good place to start. Talking about how to pay for long-term care, you can self-fund, and I would recommend that if your parents have a slightly more complex basket of assets, they might have a couple rental properties, they might have some savings, they might have some IRAs, some CDs, and some home equity, right? You might want to talk to them about the order of liquidation. Now, what do I mean by an order of liquidation? Well, if they run out of, if they don't want to run out of cash, they may have to look at selling a rental. Well, that precipitates a tax discussion, right? Because now if you sell a rental, then you may be paying capital gains tax. You may have to kick some of the tenants out, or they may end up getting kicked out by the new buyer. So self-funding is where you write the check. Jeff, how much is the average skilled nursing care resident? What's the average charge per month in California?
Yeah, for the state of California, I think it's around $12,000 or $13,000.
Yeah, it's very, very high. And my father-in-law's in assisted living, and I think his bill is about $6,000 a month. And he just has a little room, and he's able to get up and get around. And but it's very, very expensive. And so for many people, they do have to dip into savings because they simply just don't have enough income. Long-term care insurance, there are two types of long-term care insurance. There's the old long-term care, which was use it or lose it. So you'd pay in, you'd pay $300 a month or $500 or $1,000 a month. And if you never use it, all of those premiums are gone. The new way of doing long-term care insurance is saying, well, I'll just write a check for $50,000 or $100,000, and many people immediately get 3x the coverage. So if you put $100,000 into you give that to the insurance company, you get $300,000 worth of benefit. If you never use that benefit, your kids get the $100,000 that you gave to the insurance company. It's a pretty good deal. If you use the benefit, then that erodes down. So that is a more modern way. Many of our clients are public retirees, so through PERS. PERS does have a long-term care policy, but what they've done is they've shrunk the benefit and they've raised the premium because they were basically weren't charging enough on premiums. And we have one client who's been in a nursing home. He was on the CalPERS program for literally like 3 months, went into a nursing home, and I think he's been there for 20 years. So I think he might have bankrupted the whole thing. Government aid, Medicaid in California, that's Medi-Cal. That is healthcare for poor people. If you can't afford to pay the $10,000 or the $12,000 a month, if you can't afford to pay it, you're just going to spend all your assets down until you're down to $2,000, and then you go on Medi-Cal. Or you can go, if you're a retired veteran or wartime vet, you can get something called aid in attendance, which my father-in-law is receiving, and that's a little over a couple $1,000 a month. So that can help. Medi-Cal you can only get in the nursing home. If you're in a skilled nursing care facility, aid in attendance you can get even if you're at home. So it's a much better alternative. A Medi-Cal Asset Protection Trust is a vehicle if you are taking care of an elder and you're worried that they're going to run out of money or they're facing having to move into a facility. Please give us a call and we can talk to you. It might not be too late to plan. A Veterans Asset Protection, I know I'm kind of going through this quickly, but a Veterans Asset Protection Trust, make sure you find the DD 214, and there's a 3-year look back on the veterans benefits. There is no look back on Medi-Cal. So we're doing a presentation on this in December. Something to be aware of. I just want to touch briefly on this. If your parent is employing a caregiver, please do yourself a favor and go through an agency. If you hire someone off Craigslist or whatever, we've had clients in the past be sued for labor law violations. If you are an owner of a business or involved in California labor law, California has crazy labor laws. Something you need to be aware of. If your parent is hiring the caregiver, or theoretically, if it's through an agency, if you independently direct the caregiver on when to give your parent medication or when to give your parent lunch or dinner, or when the caregiver should take a break, or when the caregiver should be working at your parent's house or not, you as the child may under California law be deemed the employer. so that if there's a wage and hour violation, you're liable. You're 100% personally liable. So this is even if you're not employing the caregiver, you're just directing the caregiver. So California has just crazy laws. Also, if the trustee is directing that, the trustee can have liability. Jeff, you want to talk about death? The responsibility of death when people
My favorite
pass away?
topic.
Yeah, death. Hey, go for it.
You know, I'm very much a do-it-yourselfer. I got a new bed recently, and rather than pay the delivery people like the $15 to set up the mattress frame, I insisted on doing it myself, and I did it completely wrong. And I think a lot of people have the urge to do it yourself when someone passes away, right? How hard can it be? There's a property, we just need to record a deed and transfer the property, but that's not the case. So you really, I would recommend calling an expert attorney, getting that initial advice. We offer a free 15-minute consultation to people who are, in this position, right? And, a lot of times, the old adage is when someone passes away, don't do anything, right? Don't do anything for a year. That's not necessarily the advice that we give people. Our advice is don't do anything major, but call an attorney right away, right? And don't do anything without consulting an attorney, frankly. So some of the things that, come into play when someone passes away are taxes, right? And, one of the kind of scary things is when you do pass away, there are like 4 or 5 different taxes that all kind of come down at once. And if you haven't properly planned for these taxes, or if you don't, work with a CPA or a tax advisor or a professional, you can really end up shooting yourself in the foot, and maybe worse, putting the other beneficiaries in a poor position. And then you're potentially personally liable for what you've done. So some of the taxes here are probably going to be familiar to you, right? There are income tax considerations when someone passes away. There are definitely property tax considerations when people pass away. So property tax in California, we know it best as Prop 13. We're going to talk about that in a few minutes. But basically, when someone passes away and the property changes to a new owner, the general rule is that the property tax gets reassessed, right? Now, there are some limited exceptions to that rule or exclusions, and we're going to go over that. Capital gains taxes may come into play. Now, a lot of times when someone passes away and another person inherits assets, frequently they can get what's called a stepped up basis or an adjusted cost basis. It's not always a stepped up basis. And we're going to talk about what that means a few slides from now. But on a lot of these taxes, sometimes you need to do something in order to claim the benefit, right? Some of these are use it or lose it things. Some of them are time sensitive, and you really got to be on it when it comes to the taxes that come into play. Another big one is the death tax. This is also known as the estate tax or the inheritance tax. That's a transfer on wealth when someone passes away. Now, we're living in a day and age where the threshold for how much wealth you can transfer upon your death and during your lifetime is as high as it's ever been before. And those laws are most likely, they're almost certain to change. Either in the next 5 years or 5 years from now, they're scheduled to change, right? So, this is something that's very important to be mindful of when someone dies. It's arguably more important to be mindful about these things before you die, right? Because you're very limited in what your planning opportunities are after the person's passed away.
We had somebody make a comment about the last slide. Another care pitfall is paying yourself if you are doing the care. That can be a real problem, especially if you have siblings or other beneficiaries who don't agree, right? So again, makes sense to engage an expert and make sure that you do it the right way. Make sure that you get good advice, right? This is not an area for a generalist. This is definitely an area for a specialist. So Proposition 13, we had 2 propositions, 15 and 19. We did a webinar on Saturday, and I see some names, I think, that attended that webinar on Saturday. This is a very brief recap of our of our webinar. I would encourage you to go to our YouTube page. It's at section 9, having to do with taxes. And that's the full, it's basically like a 2-hour webinar. An hour takes a deep dive with an hour of questions. So very common questions. Prop 15 is the one that would have reassessed all commercial property. That failed by a thin margin. Prop 19 passed by a thin margin. And so what Prop 19 does is it takes away the parent-to-child reassessment exclusion. But to understand Prop 13, or to understand Prop 19 from 2020, you do need to understand Prop 13 from 1978. And so this is me in the 1970s. That's my dad, and that's my mom. And you'll notice my dad has a pipe and my mom has a cigarette. And that's me, my puka shell necklace. And that's his Lincoln Continental in the back, the 70s Lincoln Continental. They bought a condo in Ventura for $30,000. Can you believe that, Jeff? Buying a condo in Ventura for $30,000.
That's how much I spent on my bed, Jim.
Right. And they moved out a year later. And the property now is worth $435,000. I think this is the story of a lot of homeowners in California. Now you can add a 0 on these numbers. You know, if they would have bought a beach house for $300,000, of course, that was, Jeff, this was 1970s dollars. I can tell you $30,000 was a lot of money in the 1970s. But their assessment's $71,000. Now, here's what's going on. Their property taxes are $834 a year. Here's what you need to understand about Prop 13. Your property is reassessed when there's a change in ownership. The property is reassessed at fair market value. They bought the condo brand new for $30,000. That was the fair market value of the condo. Every year thereafter, Prop 13 says the maximum that the taxes can go up is 2% per year. The problem is real estate goes up at more than 4% a year. Since the 70s, it's gone up at more than 4% a year. So you have this disconnect between assessed value that goes up rather slowly and market value that's going up rather quickly. And so what you have is my parents who pay $834,000. Now, if they sold the same condo to a new couple with a new kid about my age in that picture, the same family buys the same condo, the property taxes are $5,000 a year. So this is the crazy Prop 13 tax structure. Prop 13 is an extremely valuable tax benefit. I mean, look at that, 800 versus 5,000. The rent is the same, right? So let's say that couple decided to move out a year later and they rented the property out. Their rents would be the same. The rents that my parents receive would be the same, but the property taxes that you pay are much, much lower. So it's important to understand this is a very valuable property right. The parent-to-child reassessment exclusion is going away effective February 16th. So what I mentioned was once there's a change in ownership, it's assessed at 1% of market value, and then there's a cap. So property is reassessed when there is a change in ownership. And now sometimes property will change hands, but it's not necessarily a change in ownership. But sometimes it is a change in ownership, and it's reassessed unless an exemption applies, unless an exclusion applies. Presently, parents can leave a primary home of any value to their children, and there's no reassessment. I was on a call this afternoon with an attorney in Ventura. It was a group call or a Zoom call, Zoom video, whatever. And he says, you know, I've got a client who's got a beachfront home in Ventura, and the property taxes are $2,700 a year, and the property's worth $4.5 million. The family wants to keep, because if that house goes to the kids and is reassessed, the taxes are going to be about $50,000 a year. The kids cannot pay $50,000 a year in property taxes. They can pay $2,700. They can't pay $50,000. They'd have to sell the house, and the kids want to keep that house. I mean, who wouldn't want to keep a family beach house in Ventura, right? I mean, that's a great thing. Right now, under current law, that house can go parent to child and is not reassessed. The Prop 19 unravels that. Prop 19 takes that away. Each individual can leave $1 million of assessed value of property to their children in addition to the home. So a home of any value, so that $4 million beachfront home can be left to the kids under current law, and there's no reassessment, plus an additional $1 million assessed value. So you might, and we have a few examples here to show you. Now, Prop 19 is effective February 16 of 2021. And So there's some good stuff in Prop 19. So that, you know, Prop 19 giveth and it taketh away. Well, here's the giveth part. Prop 19 allows you to take your Prop 13 tax base with you to a new home 3 times in your life, anywhere in California, even if you buy a more expensive property. This is a very powerful planning tool for people who are 55 and over, right? If you're over 55, and we're not sure what that means. Is it 55 and a day? Is it the day after your 55th birthday? Is it age 56? We don't know yet. It's kind of a poorly written law. Even if you buy a more expensive property, you can take your Prop 13 tax base with you. If you buy a more expensive property, if the market value is a little bit more, you're going to be assessed on that increase in value. And we have a question. When you say a parent can leave, do you mean gift or must be a parent pass? Gift, inheritance, transfer, change in ownership. By the way, death is a change in ownership. A gift is a change in ownership. A sale is a change in ownership. Okay. So let's look at this example. We have an example of a husband and wife buy a home in Pasadena in 1980 for $200,000. That is the home right there, the Craftsman home. Today it's worth $1.2 million. The husband and wife pay property taxes of $5,000 a year. Husband and wife to sell the Pasadena home. They moved to Northern California to Roseville to be closer to their daughter for $700,000. They continue to pay $5,000 a year in property tax instead of $8,500. Okay, so they're saving. They get to take their property tax base to Placer County. Husband and wife buy a home in Pasadena for 1980 for $200,000. Same house. Today it's worth $1.2 million. Same facts. Husband and wife pay property taxes of $5,000. They sell their Pasadena home and buy a home in Carlsbad for $3.2 million, and that's the home right there. The first $1.2 million of the new home is taxed at $5,000 a year. The next $2 million, because they bought a home greater in value, is taxed at current rates of $25,000 a year. The annual tax with Prop 19 is $26,000. If they did not have Prop 19, in this example, their property taxes would be $14,000 higher. So this is an example where Prop 19 benefits homeowners, benefits people who currently own the home, who currently have the Prop 13 tax benefit, but it does destroy the parent-to-child reassessment exclusion. The bad stuff about Prop 19, parent-to-child transfers that are excluded from reassessment are entirely eliminated. However, there is one narrow exception. A parent-to-child change in ownership, CIO's change in ownership, by gift, inheritance, or sale is not reassessed, but, and this is a big but, the child must live in the property when the parents pass away or give it or sell it to the client. And the anything above $1 million beyond the assessed value is reassessed. And I'll give you an example that explains that. A little bit kind of a difficult concept to understand. So you'll see that in the example. So this effectively increases the cost of keeping an inherited property. Now, here's the deal. The statute's effective February 16th. So any transfer February 16th and later, which is a deed that you record at the recorder's office, okay? But the problem is that's a Tuesday. Washington's birthday is February 15th, which is the Monday before the 16th. That's a holiday. The recorder's office is closed. The Sunday and the Saturday before February 15th, the recorder's office is closed. And guess what? It's Lincoln's birthday on February 12th. The recorder's office is closed on February 12th. So this is one example of why you really need to hire an expert, because lawyers know to look at all these baloney rules. They're like, if there's a deadline, is the government office even open to record the deed? This is what lawyers are trained to do, by the way. This is our training. A normal person would say, oh, I've got till the 16th. I can walk down on the 15th and record the deed. The real deadline's February 11th. So it's 5 days shorter. Prop 13, parent-to-child reassessment exclusion, which is really Prop 58, but people hear of Prop 15. The parent-to-child transfers, the exclusion on reassessment is eliminated for residential rentals, commercial, industrial, and family vacation and cabins. All of those get reassessed effective February 16. We have gotten a massive response from our clients who have set appointments with us to go over their individual situation so that they can find out, do I need to do something before February 16th or not? Okay, so that's kind of the fork in the road. Do I need to do something, some extra planning by February 16th? Or the way my estate plan is, if your kids are going to sell the property anyway when you pass away, there's no reason to do anything, right? For Prop 19, there might be reasons to do things for other reasons, but specifically for Prop 19, there may not be a reason to do any planning now. So how do Proposition 13 taxes work now when a parent dies and leaves a property to a child, at least until February 15th? This is an example of a home in West LA. This is actually a real example. These are real examples. I went online and I Googled house for sale, West LA, 1.7 million. And this is a house in West LA that is listed for 1.7 million. Tony asks, how do you pay for the recording if you e-file a new deed? Typically with a credit, I don't know, a credit card, I'm assuming, but you can e-file deeds. And that's what we're doing now because of, it's about a month delay in many recorders' offices. So you'll submit the paperwork and you won't get the recorded stamp until a month later. So that's another issue is e-filing. So mom and dad, at least until February 15th, mom and dad buy this West LA home in the 1970s for $100,000. It's now worth $1.7 million. The assessed value is $200,000. The child inherits. If the child files a claim for reassessment exclusion between parent and child, the assessed value remains at the parent's assessed value of $200,000. The taxes stay at $2,500 per year. And this is one of the most important parts of Prop 13. It's not what your taxes are this year. It's how much can they go up year over year. So it's kind of a snowball effect. So in this case, the taxes can only go up 2% a year maximum, which is $50 a year. I mean, come on, that's not $50, Jeff. That's like you go out with Lindsay and a couple of friends and you buy 4 lattes or something. I don't know. That's nothing, $50 a year. After February 15th, look at this, folks. This is crazy. The same house, $100,000 home. Now it's gone up to $1.7 million, assessed value $200,000. When the child inherits, the kid has to move into mom and dad's home. Now, I don't know about you, but a lot of kids are like, I already have a house. I don't want to move into my parents' home. I grew up in West LA, but I'm living in the Bay Area. For Southern California people, that would be, the Bay Area is San Francisco Bay Area, not South Bay, Torrance, right? I don't want to move back to LA. My life is in Northern California. So the house gets reassessed. So let's say the kid moves into the house. So the kid keeps the $200,000 assessment. The next $1 million in value is not reassessed. So that takes us up to $1.2 million. But everything over $1.2 million, that's reassessed. So the child's assessed value is $200,000 plus the amount over that $1.2 million. So the property taxes jump from $2,500 a year to $8,700 a year. And for a lot of people, they simply can't afford $8,700 a year in property taxes. I mean, now it's starting to that's a lot of money, okay? And most importantly, or also important, they can go up $175 a year. Now, what if the kid never lives in the house? Here's what happens. Same house, same facts, assessed value $200,000. Let's say the parents rent the home out while the parents go to assisted living. They can't live there anymore. Rent on a house like that might be $8,000 a month. I don't know what that's going to rent for. That might really help the parents pay for assisted living. So the parents move to assisted living. When the child inherits the property, because the parents did not occupy that home as their primary residence, because they were renting it out, the property's reassessed, the property taxes go up almost tenfold to $2,150 per year, and they increase at $400 a year thereafter. Folks, this is Prop 19 after February 15th of 2021. So this really changes the landscape. We are getting so many people calling us. Typically, these are people who may have homes on the peninsula in San Francisco Peninsula or Bay Area, a lot of coastal Southern California, a lot of coastal properties. These are properties that maybe they've been in the family 40, 50 years. These assessments are going to really go crazy high. Any thoughts, Jeff?
I think this is going to be one of those things where people are going to wake up to this next year and look back at this last 3 months and wish they had done something. I think people are going to have a lot of regrets that they didn't take some action.
And what I did is I quantified it. Let's say the child holds this property 25 years. With Prop 13 on this specific case, it's $80,000 in taxes. It's $200,000 higher with Prop 19. That's even if you move into your parents' house. Now, the question is, how long do you have to live there? That's an open question. Are you stuck there living for life? I don't know. Will it get reassessed if you move? I don't know. Prop 19 on a rental, an extra $600,000. That's a lot of money. We are recommending that you take a look at this now to protect your Prop 13 for your children, especially with the SALT deduction. The state and local tax deduction is capped at $10,000. So if the kids wanted to move into the Prop 19 on a rental, let's say the kids want to move in there and actually occupy the home, but because the parents weren't living there because they'd rented it out, they're going to pay an extra $600,000 over a 25-year period. This is real money. What about multifamily, commercial? This is non-owner occupied, and industrial properties. Same scenario. This, and Jeff and I see this situation a ton with clients. This is a fourplex in LA. Very common to see this situation. Very common in the Bay Area as well, San Francisco Bay Area. Lori buys a fourplex, $100,000 fourplex in 1975. It's worth $2 million. The current tax bill is $3,100. When the kids inherit the fourplex, the taxes jump to $25,000 a year. Again, they're going up almost tenfold. Prop 19 means higher property taxes when the parent dies, but you can plan now to preserve that Prop 13, and the clients should really think about looking at alternatives. Does it make sense to preserve Prop 13? Because I think going forward after February 15th, many kids are going to be selling these properties. They're just going to be like, you know what? It's not worth it. The leaky faucets and the plugged up toilets, it's just not worth it. Right.
And
so
I think
I
think it's worth noting that, that was really one of the major designs of the proposition itself, was to encourage people to sell properties.
Yeah. It's back. The biggest backer was the California Association of Realtors. And I'm not saying I'm not saying it's a bad thing, because I think there's a lot of good in Prop 19, but it had to be paid somehow, right? Somehow, some way it had to be paid for. So your taxes are literally 8 times what they otherwise would have been. Now, here's a real issue. In many cities, the city of Los Angeles, the city and county of San Francisco, the Santa Monica, many municipalities do have rent control. So what if your property taxes go way up? That may consume your entire rents if those tenants have been there a long time. When my wife and I first got married, we lived in LA near the Miracle Mile, and we lived in a 1-bedroom, 1-bath apartment. I think our rent was $800 a month, $850 or something. And the neighbor who was downstairs, and this was 1992, the neighbor downstairs had been there since the 1950s, and his rent was like $300 a month. And there are people that have been there literally 50 years in an apartment, right? And they're protected under rent control. We can debate the merits of rent control, but the point is, where there is rent control, that may be the numbers may just not add up. Now, can you just give your property away? Well, yeah, you can. It's easy. I'm not recommending you do, because you're going to lose control. I was talking to a lawyer this week who has a client who is being evicted by his son out of his own house because the client put the house into the son's name. That is not uncommon. Okay. So we don't recommend that. That's a bad idea. I think we would be doing our clients a disservice to recommend that. In very limited circumstances, a super wealthy person, maybe. But something to be aware of is your basis carries over. So, and we're going to go through an example on what basis is and how it works. It's also subject to your child's divorce, lawsuits, bankruptcy, loss of rental income, a whole host of issues, and it is unlikely to be appropriate for the vast majority of people. You want to talk about what capital gains tax is, Jeff?
Yeah. So, if you sell something and you make a profit on it, typically you're paying capital gains tax on it. So if you buy, a house or a stock or another security, and you pay 5 for it, and later you sell it for 7, you don't have to pay tax on that whole 7. You just have to pay tax on what your gain is. So your gain would be 7 minus 5 is 2. And the fancy tax word for kind of what you bought it for, that number that you use to calculate how much profit or gain you are recognizing is your basis, right? So you always have to keep track of your basis. When you eventually sell an asset, you need to report your gain, and you can't do that unless you know what your basis is. So generally speaking, the sales price when you sell an asset minus the basis is your taxable gain. And here's a real great advantage that applies a lot of the time, but not all of the time, is at death, property generally gets an adjusted basis, which means the basis is reset to the fair market value of that asset at the date of death, right? So if it's a piece of real estate and that original owner bought it for 5, but now it's worth 12 when they pass away, if it's subject to an adjusted basis, that new basis would be 12. Now, how do you determine that? Well, in real estate, you usually are required to get an appraisal, right? And that determines the fair market value, and that's the adjusted basis. A lot of times we refer to this as the stepped up basis, because in most instances, real estate and securities will have gone up in value over time. So they've appreciated. So that basis is being stepped up from the original purchase price. But it's not always stepped up. Sometimes it can be a step down basis if that asset has depreciated over time. But the bottom line is your basis is a very important concept. And, you know, for a lot of people, they see a lot of value in preserving that adjusted basis, right? So when it comes to the impact of Prop 19, and I know Jim's eager to talk about this in the upcoming slides, you know, a lot of times you're balancing, you know, getting preferential treatment on the property tax side of things and getting this adjusted basis when someone passes away. So in a perfect world, we get the best of both worlds and we design a plan where you can accomplish both of those. I'm going to leave it up to Jim to kind of comment on, you know, whether that's a possibility and what kind of planning we're typically, you know, suggesting to some of our clients who are concerned about this right now.
It's interesting. I was on a call at the Zoom meeting with lawyers, and this older lawyer I respect a lot, he says, you know, well, you could do half. Maybe half of the property gets reassessed and half gets an adjusted cost basis. So, and this is why you really need to talk to an expert, because we run the numbers and we figure out what's the best, you know, what is the best method to arrive at your overall estate planning goals. Okay, so remember Lori's fourplex that she bought in 1975, it's worth $2 million. Here's an example of basis. If Lori sells it now, she'll have an $1.8 million gain because the property went up. And well, I have a $1.9 million gain plus the depreciation, recapture depreciation. So it's a $1.93 million gain. This is going to be taxed at her federal capital gains rate plus state, because she's in California. Now on recapture of depreciation, that's $70,000. She's actually paying 42.1%. It's a huge tax rate. Straight gain is 37.1. The death tax rate is 40%. So this is a balancing that we go through, and we look at it and we say, well, on balance, does it make sense to make a gift to preserve Prop 13, or does it make sense to keep it in the estate and get an adjusted cost basis? So it just depends. It depends all around, right? So the tax bill's over $700,000. If Lori dies and then the kids inherit the property, it gets an adjusted cost basis. The kids pay 0 in tax. Now, this is really good for the kids, not so good for Lori, because Lori's dead, right? She has to die to get this. So this is why a lot of older people hold on to property until they pass away. So many of our clients, when we meet with them and they say, Jim, should I do something because of Prop 19? We ask them, are you going to keep this fourplex or not? If they say, heck no, man, once we can get an adjusted cost basis on that thing, we're out of there. We're tired of dealing with that. So it just really depends on your overall situation. Should Lori give the property to her kids? Again, the kids take Lori's low property tax base. On a fourplex commercial or multifamily, probably not as big of an emotional attachment. But again, if we're talking about that beachfront home or the lakefront home, you know, these homes are well over $1 million everywhere in California, even in remote areas. That's something, if it's a family retreat, a family home, you may not be as concerned about cost basis. And so that's going to play into it. There is a better way. There must be a better way. There is a better way. What we are recommending that clients consider is doing effectively what we're calling a Prop 13 trust. It's where the parent keeps control of the property. So it can't be taken away by the kid's bankruptcy or divorce. You may have to forego an adjusted cost basis, maybe not. We're working with the Board of Equalization as we speak, trying to figure out if there's a way where we can essentially have our cake and eat it too. I'm not holding out a lot of hope on that, frankly, because, you know, as they say, pigs get fat and hogs get slaughtered. If you try and gobble up too much, you're going to be taken out. So there is no one size fits all. Each plan is highly dependent on a much broader set of facts than your living trust. You're really looking at what people are going to do with this property after you're gone, and just the interplay, the family dynamics. In the United States for 2020, you can leave $11,580,000 tax-free per person. If you gave away $11,500,000, you know, if you have a net worth of $20 million and you're single and you want to give away $11.58 million, you can give that away and there's no look back. Okay. So we have, and Jeff and I are working on several matters right now, very high net worth people that are giving away, they are using up their exemption. And, you know, one problem is if you give away $2 million, the IRS's position that if we end up with a $3.5 million Biden exemption, that you're giving away not the exemption over that $3.5 million, but you're giving away what you end up with when you pass away. So in order to make this really efficient, tax efficient, you really do need to be considering giving away more than probably 5 million or something like that. So another thing is California may impose their own death tax. That's certainly in the cards. Gift tax return. If you make a gift to your property, you must file a gift tax return. It's very, very important. You may owe gift tax, probably not, because we have an $11.58 million exemption. Go to Cunningham Legal, make an appointment. Here's what we're doing. The question is, should you seek advice? I know we're hitting a lot of Prop 19 here, a lot of real estate transactions. This is kind of a mashup of two topics on the webinar. If your kids are going to keep one or more of your properties as a rental, a vacation home, or primary home, then we strongly urge you to consider, I'm not suggesting you make a gift, but consider a gifting strategy. And if your kids are going to sell your property after you pass away, it may not make sense, right? But seek advice from an expert Prop 13 lawyer. And I will tell you, there are not many of us. A very, very rare bird. You can go to Cunningham Legal, book your appointment, and that's at CunninghamLegal.com. Now, there's two types of appointments we're going to talk about here. If you're talking about just general, hey, my mom's getting sick, that is a free 15-minute call. Go ahead and book that. If you really want to get deep into Prop 13 and you go, wow, this is a real issue for my parents, and I really want to analyze this and figure out if we need to make a change to our estate plan, what we're doing is we are offering that up as a service. That consult is there's a B trust here. Let's see here. Whoops, I went the wrong way. Whoops, it's over. Let's see here. So here's what I'm going to wrap this up. You can call 866-988-3956 or 530-269-1515, or go online, however you want to access us. To do a Prop 13 analysis, we're charging a $500 fee. And what that is we look at your property tax bill or your parents' property tax bill. We look at what your parents' assets are, or your assets, depending on who this is, and their current estate plan or your current estate plan. We look at all of that. We spend an hour, we do some prep. We spend about an hour with each client. And then you decide at that point, does it make sense to do some further planning or not? It's a fork in the road. That is a lot of work that we're putting into each of these appointments. If you would just like a general call about like, hey, my parents are getting sick, or they passed away, do I even need a lawyer? If it has nothing to do with Prop 13 and Prop 19, that's a free 15-minute call. Just call. And I know this may be a little confusing for you guys, but I do want to offer up, if it is a Prop 19 issue, that is a meaningful 1 hour time slot. And we're just kind of quickly running out of time on these. I don't know our schedules. We got the Thanksgiving holiday. We have other end of the year planning. I'm afraid we very well may run out of time on this. So I would urge you to call 530-269-1515 and set up a time to call. Any remaining questions, closing remarks? I know we're over our typical 1 hour time slot. Any thoughts, Jeff? And we'll open it up for Q&A.
Well, this is really just a practical recommendation here. But if you're sitting there thinking, hey, this was a confusing webinar. I've heard a lot of, intricate stuff being talked about, and you kind of lost me somewhere there. That's the nature of property tax, right? It's a complex beast. But there's a solution to it. And, we're trained to help you on it. Now, I will say, if you're sitting there thinking, hey, this might be a good investment of my time to talk with me or Jim or another lawyer here. Number two, collect those property tax bills. Start getting them right now, right? And those give us a whole lot of valuable information to do the initial analysis. So I encourage all of you guys to, if you're sensitive to this, sign up for a consultation, and we will help you.
All right. With that, it was yet another great webinar. Great to spend time with you guys. And we look forward to talking to you soon.
Yeah. See y'all later.